Hello, everyone, and welcome back to the main stage. We hope that many of you had a chance to participate in the biological network informational sessions. We'll be hearing much more about the biological networks tomorrow, both in the plenary talks and panel discussion, as well as in another round of breakouts to actually talk about sort of mapping the future ahead for the biological networks. Right now, we're going to switch gears a little bit and turn to a topic that is very much front and center right now in the context of the HCA consortium, and that is compliance with data protection regulations, both worldwide, but specifically for this talk, the EU law known as the General Data Protection Regulation, GDPR. And we're very fortunate to have Sarion here to give us an introduction to GDPR and also to discuss what the implications are for HCA and what the procedures are being put in place to ensure that we are really compliant with this regulation in particular. Although, of course, the general principles will apply to other regulations as well. Sarion has a background that's very much close to mine, actually. She was a postdoc and a PhD in biochemistry and then moved into a successful career in science policy. She's been with the Wellcome Sanger Institute since 2014, the last 5 years, I believe, as the head of policy at the Sanger Institute. She's also been a core member of 2 ad hoc working groups within HCA that's really been exploring really been mapping out a strategy for how HCA should address GDPR. And she's also a member of the ethics working group as well, which has also had some key input into that discussion. So we're very pleased to have her here, and Sarion, welcome, and we look forward to your talk.
Thank you, John. So as John says, I'm Sarion Bowers. I'm head of policy at the Sanger Institute, and I have been coordinating the HCA GDPR task force for the last it can't be 3 years, but maybe 3 years. So I know that if you've been sorry, I'm slightly trouble moving my slides forward. There we go. Okay, so I know if you've seen me give this talk before, you've probably seen some of the slides at the beginning, but I do have a quite significant update from the last time I spoke to you. I think for people who aren't so familiar with GDPR, and I think we have quite a large audience tonight, it's helpful to sort of go back to think about the origins of GDPR and what GDPR is trying to achieve. So GDPR was first conceived in 2012, and when you think about the world in 2012, it was quite a different place. That was the year that Malala Yousafzai was shot and came to Britain. It was the year that Obama ran against Mitt Romney in the 2012 election, which does seem an awfully long time ago. It was, we had the big phone hacking scandal in the UK, and so the world was quite a different place. Data had a very different function in the world at that time, and GDPR was very much conceived within that world. And genomics was also quite different. So these are some headlines from 2012. So we had news stories about single genomes that probably these days wouldn't make headline news unless it was something particularly significant. So we had the 1,000 Genomes Project, and Oxford Nanopore was bringing its first product out to market. So genomics was also significantly simpler than what we're looking at right now. And so what was GDPR really trying to achieve? I mean, fundamentally, it was an update to the Data Protection Directive from 1995. It really wanted to strengthen the data subject rights and increase transparency requirements. So transparency requirements just means that the organizations that are processing data have to have better accountability. So they need to be recording what they're doing with data, and they need to be telling individuals what's happened to their data. And this isn't actually so different from what was in law before, but there's more teeth behind it, basically, and there's a requirement to do it, whereas before there wasn't much consequence for not doing it. The other fundamental purpose of GDPR was really to harmonise across the EU. So GDPR is a regulation as opposed to a directive, which basically means it is implemented directly into member state law versus a directive where each individual country implements its own version of the legislation. And GDPR was fundamentally really about commercial uses of data, so things like insurance and marketing. And actually, the initial proposals about GDPR really didn't get very much attention. It was fairly low key. It was a not too radical update to that directive. But then we had the whistleblowing from Edward Snowden, And that really shook, I think, a lot of governments' views about how data was being used, about surveillance, about sort of state reach into citizens' private data. And the result was that the legislation that had been proposed by the European Commission was being reviewed by the European Parliament, and they this flagged a lot of concerns, and they ended up making suggesting a lot of amendments that really then got the attention of scientists. And I think a lot of the discussions that happened and a lot of the proposed changes really scared scientists, because it would have become very difficult to operate under those rules. And I think although compromise was reached and a lot of those things didn't happen, I think a lot of the conversations, particularly about the requirements to have consent for everything, have still kind of muddied the waters a bit, and there's still very much this sense that the legislation requires consent and that it's much more draconian than actually it is. It's more pragmatic than I think people realise. So I realise that any lawyers in the audience are probably horrified at the idea of using word cloud to analyse a piece of legislation. But if you look at what data protection is really focusing, the GDPR legislation is really focusing on, obviously primarily it's focusing on data, but it's really looking at processing, at rights, at safeguards. That's what it's about. But then if you start drilling down into what it's focusing on, the words health, scientific, and genetic actually get mentioned a lot more than things like financial and marketing. And this initially might make you think that actually the legislation is more heavily regulating science and health, but actually I would argue that it's the opposite, that this legislation is actually carving out special rules for science. It recognises that scientific research is, it occupies a special place in society, and that you can't apply the same rules that you would apply to a commercial organisation if you're doing science. And I think this is slightly borne out by the fact that if you look at the recitals for the legislation, which are basically the drafters kind of the explanatory notes for the legislation, there's a lot of mentions. So most, probably over half of the mentions of health, science and genetics are actually in those recitals, because there's a lot of focus on explaining what they mean by all of this and what the rules are. So what does GDPR say? I am going to show quite a bit of text here. I'm not going to read them all out because nobody wants articles of legislation being read out. But the first thing that is important in GDPR is it defines what personal data is. And in this instance, it means that it's any information that effectively allows you to identify an individual. And it gives things like identification number, location data, identifier, that kind of thing. But specifically, and for the first time in European data protection legislation, it mentions the word genetic. And this, in fact, was so novel and so new that it ended up with its own recital, which is this explanatory note. So there is an explanation of what the legislators view as by meaning genetic. And so I think for a scientist, this probably makes a lot of sense, that it's the inherited or acquired genetic characteristics of a natural person. But if at first glance, it's quite easy to think that this is saying that all genetic data is personal data, but it's not saying that. What it's actually saying is that genetic personal data is defined as the inherited or acquired characteristics. So that means that actually there's still quite a big question mark around when is genetic data personal data, and there's very little guidance on this. So having defined personal data allows a caveat that it's unclear about genetic data. You then need to find what's called a lawful basis, or sometimes called a legal basis. So this is laid out in Article 6, and basically this says that it's illegal to process any personal data unless you can satisfy one of these conditions. And for scientists in general, you would be looking at either consent, which is A, or public interest, which is E, or legitimate interest, which is F. Those are the kind of basis that you'd be looking at. But GDPR also recognises that there are special categories of data. So these are kind of additional levels of data. And these are particularly sensitive. And so under the previous data protection legislation, it was often called sensitive categories of personal data. And so here it talks about racial and ethnic origin, political opinions, religious or philosophical beliefs. And you can see why these are kind of more sensitive, and there's maybe more more regulation around them, but specifically, again, genetic data is mentioned. And so genetic data, if it's personal data, now falls into this second category. So you then need a second lawful basis, which is this Article 9. So you need an Article 6 and an Article 9 lawful basis. But with Article 9, a lot of the rules here are actually based on what member states have put into their own legislation. So when after Parliament had proposed all these changes to the legislation, the compromise that eventually happened to get the legislation passed was that they broadly agreed one legislation, but then they had a few exemptions for research, which they left up to the member states to implement themselves. And this is important for HCA. And the final piece really for HCA in terms of what GDPR says and where it's important is really around the data subject rights. And so the data subjects are just you and me, we're the people whose data is being collected and is being used by organizations. And so GDPR lays out quite a few rights for data subjects. So it tells organizations who are processing personal data what information they must provide to individuals whose data is being gathered. It also tells you that if you're an organization who's getting this data from a third party, you still need to tell the data subject things about the use of their data. As data subjects, we have a right to access data. We have a right to correct incorrect personal data. So where organizations potentially are holding things that are not correct about us. So insurance companies, for example, have a right to have that data. We have a right to be forgotten, to have the data deleted. We have a right to temporarily restrict processing. Companies have to tell data subjects that they're going to delete their data or change the data to correct it. There is a limited right about being able to go to an organization and get your data in a format that is compatible for other organizations to process it. This is quite a limited right, but it's a new one. You also have the right to object to processing, and then there's also the right to have any decision making that's been done in an automated way reviewed by a person. So there's quite a lot of rights in there, and organizations that are processing data have to abide by these rights and have to have processes in place that allow them to fulfill those rights. But there are exemptions for research. So this is part of why there's all those mentions of science and health and genetics in GDPR, because it does specifically lay out some conditions for scientists to be able to get exemptions to these rights. So why does this matter to HCA? Why does HCA care so much? Well, HCA there's several reasons, but the first is that HCA is a global organisation, but there's a huge concentration of research institutes who've signed up to participate based in Europe. So they're collecting a lot of European citizens' data. If GDPR covers that, then that's a very large set of data that's being gathered from a lot of member states. The Human Cell Atlas has principles and values around privacy and ethics, but also fundamentally about data sharing, which makes GDPR particularly relevant to the activities of HCA. Obviously, HCA is collecting a lot of data. You've got molecular measurements, you've got the raw sequence data and process sequence data. You've also got metadata as well that are being obtained from deceased and living donors. And all of this is kind of actualized in the data coordination platform. So all of the data is being brought into this platform, is being organized there, and then is made accessible to the research community. And it needs to be done without compromising data privacy, and in line with the values of HCA, it has to be trustworthy, ethical, and fundamentally lawful. So this raised, this whole situation of having this very large data collection program, a coordination platform, and this new piece of legislation raised some questions for HCA. And so really fundamentally, questions were, is the data on the DCP personal data? So is that genetic data personal data? If it is personal data, who are the data controllers of that data? What are the lawful basis for processing the data? And how do we maintain the values of HCA while complying with GDPR? So this is fundamentally, how do we find a way to share data whilst also complying with GDPR? And just to explain what a data controller is, so in the context of HCA and the DCP, the data controller is the person responsible for decisions and compliance relating to the data ingestion, retention, access on the DCP and the acceptable use policies. A data controller is also the person who can contract with data processors. So these will be third parties who are providing services to HCA. So that might be a cloud provider, for example, that, you know, so whoever is contracting with that cloud provider would be the data controller. And you can have a situation where you can have a single controller, so that's one organization, and regulators typically look to organizations rather than individuals. So you could have one organization controlling it, or you can have a situation where you have a joint controllership. And this is where you have responsibility shared by multiple institutions, and where, say, you have a large international consortia with a committee running it, and they're collecting a lot of data. All of the organizations represented on that committee could potentially be data controllers if they're collecting personal data. And you can't have one organization on that committee say, I'll be the data controller and take responsibility for all of the data. All of the organizations have to share that responsibility. So we put together a task force that involved a lot of people from HCA. We had a lot of support from Wellcome, CZI, and other places. We also had a number of academic lawyers supporting us, and we hired we got sought outside external legal counsel and worked very closely with this law firm to come up with a position, and we spent a lot of time researching and analysing the results that they came up with. And so the final kind of position and recommendations from the task force were that data from healthy deceased EU citizens is not covered by GDPR. And I realise that healthy deceased is a bit of an oxymoron, but this means where you are looking at tissues that are not related to the disease that killed the individual. So you're not looking at cancer from a deceased patient, for example. Genetic data, we didn't come to a firm position on whether genetic data from diseased or living EU donors is personal data, but it's pseudonymized, which is a safeguard. And we took the position that almost certainly not all the data was covered by GDPR, but regardless, we would treat it sensitively and put appropriate measures in place so that if it was decided it was covered by GDPR, we would be compliant. And the other finding that we came up with was that under the governance structure that we were working under at the time, the organising committee of HCA potentially could be considered a joint controller. And obviously the OC has upwards of 30 organisations on the committee. And this is complicated by the fact that a lot of the people who sit on committees, such as the OC, don't consider themselves representatives of the organisation that they work for, and the organisation that they work for doesn't consider them representatives. And so you have people sitting there on the committee who probably aren't aware that they have this responsibility, and the organisations they work for almost certainly have not given consideration to this. And so as a result, the recommendations from the task force that we needed to streamline and simplify data controllership, having 30 organisations around the world trying to control it was possible, but complicated. And if we were going to streamline the data controllership, there needed to be an independent governance process that sat outside the organising committee. We also proposed the choice of lawful basis, which is required under GDPR. So we proposed the use of legitimate interest from Article 6 and scientific research purposes from Article 9. And we also initiated a data protection impact assessment. So to streamline the data governance process, we actually we proposed the creation of HCA Inc. And so this would be a US non-profit organisation with a EU entity, to facilitate the data handling. And the purpose of having an EU entity was really to take advantage of what's called the one-stop shop rules. And this basically says that if you have a presence within a member state in Europe, you can benefit from basically operating under the rules of that country, as opposed to trying to comply with all the different member states' rules on GDPR. The function of HCA is to ensure global compliance with GDPR, plus also other data protection regimes, and it will be governed by an independent board of directors with between 7 and 15 individuals on it. The proposal is that HCA Inc. will be responsible for all the decision making relating to the DCP. It will contract with the DCP service providers. It will do the data protection impact assessments and all the other required legal documents, and it will appoint a data protection officer and maintain data processing records. The HCA organising committee will continue, but they will be primarily focusing on the scientific vision of HCA, the mission of HCA, and running the working groups. And the final recommendation was that we should base the EU entity in the Netherlands. And we picked the Netherlands because for two reasons, really. So first of all, there's a very large HCA presence in the Netherlands. And the second reason is that although in theory, every European member state has the same legislation, there are these exemptions for science and research. And some member states have implemented those exemptions and others haven't, and the Netherlands have actually implemented a fairly clear framework around scientific research, which makes it a good country to be operating in, combined with our strong presence there. So we needed to really approach the Dutch Data Protection Authority in order to sort of sound them out on this. I apologise to all the Dutch people on this call, but I'm not even going to attempt to pronounce the name of the Dutch Data Protection Authority. But we worked with the lawyers, and then John, Tony, and two of the lawyers met with the Dutch Data Protection Authority. And we discussed everything that we've kind of gone through here. So they discussed setting up the entity, and the purposes of that entity. They discussed having the US and Dutch presence, the independent board of directors with 2 co-chairs, and having a data protection officer based in that entity. And then they also discussed our proposal for legal basis, looking at legitimate interest and scientific research purposes that are allowed by the Dutch implementation of GDPR, and what safeguards we're going to use. We also touched on not using consent as the lawful basis, because this is a common misconception under GDPR that you have to use consent as a lawful basis, but actually consent brings a lot of problems with it. There's a big misunderstanding about what consent means, and you can't have the exemptions to the data subject rights if you use consent, because you cannot have a situation where you'll use consent and then you don't allow someone to withdraw that consent. And the other thing that was discussed with the Data Protection Authority was transparency. So this was, what notifications we were going to give, what records we were going to keep, the data protection impact assessment, that kind of thing. And you don't get an approval from data protection authorities. They don't say yes or no. You basically get told that they don't see anything particularly wrong with what you're proposing, or they have no concerns at this point. They don't tell you it's fine. But so we got as positive a message as we could from the Data Protection Authority, which was that nothing we'd said caused any alarm bells. And so to date, we have established the US entity, which is a non-profit 501c3. The Dutch entity is going to be established at the end of this year, so either Q3 or Q4. We've retained lawyers already to do the data protection impact assessment, something that's called the legitimate interest assessment. So this is basically a requirement to show that we comply with the requirements of the legitimate interest lawful basis. There are various agreements that need to be done, privacy policy, data processing records, that kind of thing. And then we will also be retaining lawyers to provide the data protection officer services. This is effectively contracting out the DPO function, but this is still pending board approval. So that's where we are to date. I wanted to finish the talk off that, just sort of highlighting why HCA has given so much thought to this, and also why I think it's so important that it has. We live in a society that is increasingly focusing on data protection and on big data sets. And so it's not uncommon now to see headlines like this. You've got the Cambridge Analytica scandal a few years ago about trying to push elections. Google DeepMind got in trouble for trying to use health records. And then even headlines that are sort of neutral, like government nudging in the age of big data, have a sort of slightly ominous overtone to it about, you know, governments really kind of trying to shift behaviour using personal data. And in that we have, my slides seem to have frozen. Yeah, so in that we have, you know, these increasingly complex genomics programs. So obviously the Human Cell Atlas, you know, this is an article from NPR. In the UK, we've had the announcement of doing 5 million genomes project. So this is genomes from NHS patients. And then non-human, but not without its own ethical challenges. We have the Earth Biogenome Project, which is trying to sequence every species on Earth. All of these projects come with complex legal and ethical issues. They fundamentally need public trust in order for them to work. And they need to be building public trust as well to ensure their sustainability. And if you look at a project that's just getting off the ground, which is the European Health Data Space, I'm not going to go through this whole slide because it's quite detailed, but this is, you know, the European Health Data Space is all about sharing data across Europe for healthcare, but also for research and policy making. And if you look at kind of a lot of documentation, they're facing many of the same problems that HCA has faced. So, you know, uneven legislative framework, cumbersome rules, difficulties transferring data, difficulties getting uptake of data, that kind of thing, and, you know, ensuring public trust in all of this. And so having actually been through this process already, we've had an opportunity to feed into this work, which we have, and I think HCA will continue to be able to feed in and share the values that HCA built on to ensure that other massive projects like the European Health Data Space also build on those values. And also, it's important not to get it wrong. Most of the British people watching this will have heard of care.data and will know all about it, but for those who maybe don't know so much about it, this was a project in 2013, 2014 to allow access to primary care records through a centralised portal in the UK. And it was a very good idea. It had widespread support, but it completely failed because they failed to communicate with the public. So they put flyers through people's doors and people just thought they were pizza flyers and threw them out. So they didn't know what was going on. They also failed to communicate that you couldn't withdraw your consent for using the data. So there was a big confusion because it was, the public were told that they could withdraw consent, but what they actually could withdraw consent for was using their identifiable data. Their anonymized data was being used regardless. And then there was a failure to communicate with general practitioners, so this is primary care physicians. They had no idea what was going on. So when patients came to them very concerned about what's happening, they weren't able to tell patients what was going on. And the result was a disaster. It was catastrophic loss of trust in the British public. And it's now 2021, so we're nearly a decade on from this. And the UK has spent an enormous amount of time and energy trying to build public trust. We have something called the Office of the National Data Guardian that has done a huge amount of work and has even been put on a statutory footing to try and overcome the problems of this, that you know, and they've been working very hard to build public trust and build trustworthy frameworks. And I think we're still a long way from being able to actually do something like care.data. And so it's really important that just because something's a good idea does not mean that you cannot have a disaster and you cannot lose public trust. But I'm going to finish here. I'm going to finish on a quote from the recently deceased National Data Guardian, Fiona Caldecott. She said that the duty to share information can be as important as the duty to protect patient confidentiality. Now, she was fundamentally talking about patients, but I think the same is true fundamentally for HCA, that we have a responsibility to protect the confidentiality and privacy of our research participants, but actually research and sharing data are in the public interest, and it's really important that we find trustworthy and supportive ways to share that data, because otherwise the public is actually losing out if we don't do this. So I think it's really important that HCA has taken this time to come up with, you know, this solution and spent the time and energy that it has looking at GDPR. I'm going to leave it there. I just want to say thank you to everyone who has been involved in the task force, because it's not been a small piece of work, and particularly have to thank John Marioni for chairing it. I know how much he's loved it. And yeah, and also the funders, particularly Chancellor and Welcome, for the support that they've given. Thank you. I will stop sharing.
Well, thank you, Sarion. That was really excellent, and I think really thought-provoking as well. I think we're at the point where we will invite some questions from the audience. I wanted to ask you a couple of questions first while we're waiting for some questions to come in. I guess one topic I want to ask about is that I know that there is potentially some additional guidance that we're expecting over the next few months or next year or so from particularly the European Data Protection Board related to biomedical research. I know you and I think John Marioni also participated in a stakeholder meeting earlier this year on that issue. And I was wondering if you could just maybe talk a little bit about where some of those issues are that need more clarity, specifically with regard to biomedical research.
It's a good question. So I was at that meeting. I have to say it's not very clear what the European Data Protection Board is thinking at the moment. They were pretty tight-lipped about that, but I think, you know, the common themes that are really coming out are the lack of harmonization across Europe. So in theory, this is a one piece of legislation, but first of all, every member state has interpreted it slightly differently. But second of all, particularly for biomedical research, there were these exemptions to the data subject rights that were allowed, that had to be put into member state law. And so every member state has kind of allowed slightly different exemptions, has put slightly different rules. So science is really operating under a real patchwork of legislation across Europe. And I think there's a real need to harmonise that and try and come up with some sort of, where there's not, I'm not sure an umbrella solution is actually possible, but there needs to be something. The European Health Data Space is obviously really struggling with this issue at the moment, to try and create that network and that ability to do it. And there is legislation in the form of the Data Governance Act that's going to be coming, which may not help HCA, but certainly might help future initiatives.
Thank you. And I guess one of the questions I wanted to ask you to maybe expand on a little bit more is specifically from the point of view of a researcher in the EU. What do they need to be sort of aware of? And here I'm particularly thinking about the export of data outside of the EU and the different laws that might be in place in the sort of recipient country, if you want to call them that.
So that one, I definitely think you need to go and talk to your legal team, would be the first thing that I would say. So there are a variety of mechanisms by which you can transfer data. If you're transferring data to a country that has what's called an adequacy agreement, so this is where the EU has basically said, okay, that country has adequate data protection laws that are compatible with our own and maintain the same kind of standards, it becomes a lot easier to transfer, because you're sort of basically, it's like transferring to another member state. If you don't have that, then you have to use things like standard contractual clauses, which require quite a lot of time and energy to set up. And so that it's tricky, I think. You definitely need to get the lawyers involved, would be probably my short answer to that.
Thank you. And we've had a couple of questions come in. Actually, just following on that question, there's a question about just people sort of new to this topic or new to HCA, where they should look for guidance or information. You've already mentioned their local legal department. Are there other sources of information they should look to?
Yes. So I think if you're in if you're looking to transfer to a particular member state, or you're in a particular member state, most of those member states will have guidance on their Data Protection Authority websites. There are also organisations like BBMRI that have guidance out there that can help. And then also things like GA4GH also has quite a lot of, it's slightly more generic, and so you may need additional guidance, but actually GA4GH has lots of advice on kind of how to create consent templates that work. They explain the difference between consent in an ethical sense and consent in a GDPR sense, and that kind of thing. So yeah, I would probably say GA4GH actually is probably not a bad place to start. If you're in the UK, the Health Research Authority has some really good guidance that actually probably would benefit people outside the the UK as well.
And this is actually a good chance to put in a plug for the ethics working group and the ethics guidance that it's producing as well, which is all at humancellatlas.org/ethics. And so you can also find some material there as well. Another question coming in really pertains to other data protection regulations and thinking about sort of the interplay between different regulations in different jurisdictions and whether the work here on GDPR will be applicable or scalable to those other.
So this is a question that's come up a bit. So the reason why we focused on GDPR was because it was a brand new piece of legislation. It explicitly mentioned genetic data in a way that I'm not aware other data protection regulations, legislations mentioning it, although I could well be wrong. So, and so it really needed that kind of focus. GDPR is amongst the sort of highest bar of data protection regimes out there. So it's, you know, there will be nuances with different data protection regimes that mean that, you know, you can't just apply whatever you've done for GDPR to it. But broadly, I would say that it should, if you're complying with GDPR, you're well on your way to complying elsewhere. I'm certainly not going to say you're compliant because I'm not a lawyer and I don't know those data protection regimes, but yeah.
Thank you. Question. Have there been efforts to look at the amount of information inherent in single-cell RNA-seq data to inform regulatory decisions, and, for example, partnerships with data privacy experts?
So I can't say about RNA-seq in particular, but there's certainly, you know, there are, you know, studies out there that look at how identifiable data is. So Yanni Verlich is someone who spends a lot of time looking at this question. We did actually talk about this at the beginning of the task force. We spoke to several scientists. We kind of took we took some views on how inherently identifiable it was. There was very much a sense that in theory, maybe right now you might be able to in some situations, but the feeling was actually HCA is getting ever more data rich, it's getting more complex in the kind of data it's gathering. And that even if the data now is not identifiable, we should future-proof ourselves for a time when potentially the data is so rich that yes, it is identifiable. So yeah, in terms of efforts to look at it, I don't know of any particularly with RNA-seq, but there definitely have been with whole genome sequencing, that kind of thing.
And as you pointed out, it's both the genetic data, but also the metadata that's associated. Yeah. You have to be careful about. And I think we can end on one last question, which is a really interesting one, which is, have there been any changes due to COVID? Has the pandemic opened up any possibilities of working together more closely internationally?
Yes and no, I would say so. GDPR allows for relaxation of the rules in the pandemic. So I think we've seen a lot of activity that's happening under exceptional rules right now. And you know, it's allowed data sharing in a way that wouldn't normally be allowed. I don't think that means that we're going to be able to, but it certainly has not meant that there's a free fall on data sharing. You know, you can't just say, oh, we're in a pandemic, sharing everything. But I do think that, so directly, no, I don't think we're going to see a massive change, but I do think we've seen, you know, really the benefits of data sharing. I think there's a real shift in attitude amongst regulators for data sharing. We're massively seeing the benefits of it. I think, you know, the sharing of genome sequences for COVID has been, you know, transformational about how we're going to deal with infectious disease in future. So I think, yes, indirectly, we're going to see a much more favourable kind of regulatory take on data sharing, which I very much hope we are.
That's fascinating. That's a really excellent point to end on. So I want to thank you again for your presentation and for spending time with us and addressing these issues for us. Thank you.
Thank you.
And I think we will turn it over to Muzz for some closing comments.